Good afternoon, everyone. Welcome to WG University, Weber Gallagher's series of educational programs. This is our workers' compensation webinar series. I am Stephen Pateco, and I'm presenting today with Julie Kinkoff, a partner from Weber Gallagher's Employment Practice Group. Each month, we present a current topic in workers' compensation legal issues. We present both case updates and ways to manage risk in your business. Today's presentation is Solving the ADA, FMLA, and Workers' Compensation Conundrum. Next month, our topic will be Navigating the Issues Brought on by Legalization of Medical and Recreational Marijuana. If you would like to view this webinar again, share it with others, or see other WG University programs, please visit the Weber Gallagher website, and you will find copies of this presentation and others under the WG University page. Also, feel free to contact the firm with any questions using questions@wglaw.com. Let's get started.
Okay, so today we're going to be talking about workers' compensation, the FMLA, and the Americans with Disabilities Act and the Pennsylvania Human Relations Act and how they all fit together. Since the ADA and the PHRA have essentially the same provisions for our discussion today, we're going to focus on the ADA.
All right, we'll start with workers' compensation, and generally workers' compensation provides various forms of compensation, including medical benefits and wage loss benefits. Now, the management of workers' compensation claims will involve issues of extended absences and job modifications. Other laws also have a bearing on those same issues, absences and job modifications. Julie, would you tell us what issues may be raised by those other laws that cover the same ground as the workers' compensation laws?
Sure. So one of the issues that you're going to run into is when an employee is out on workers' compensation, are they also entitled to relief under the FMLA and or the ADA? Does the employee have to ask for FMLA leave, or do they have to ask for a reasonable accommodation? What happens when the employee is on workers' compensation and they're released to work, but they're released to work with restrictions? Some of the other issues that come up are light duty programs and whether those can be exclusively for employees injured on the job. And what happens if the employee on workers' compensation exhausts their FMLA leave and they're still not released to go to work? How do you deal with that? And also under the ADA, what constitutes an undue burden in order for discussions regarding reasonable accommodations?
We'll start by introducing each act, the Workers' Compensation Act first. The coverage of the Workers' Compensation Act is for job-related injuries. It sounds obvious, but that is the trigger that will tell you you have to work within the Workers' Compensation Act provisions. The other acts will have other triggers, but for our purposes, Workers' Compensation Act is invoked when there's a job-related injury. What happens after that? Benefits are provided, both medical and wage loss are the primary benefits that we're concerned with today. The wage loss benefits, particularly in a jurisdiction like Pennsylvania, which is a wage loss state, basically provides an ongoing benefit to the employee until they can return to work in one capacity or another. If they're not fully recovered, there's always going to be a residual claim for partial disability. So that's the basic benefit under the Workers' Compensation Act. Now, bear in mind that this is a no-fault act. Negligence is not considered. Whatever leads to the accident, if it's covered by the Workers' Compensation Act, negligence will not be a defense. Now, the coverage is for all employers that are not covered by a federal employer program. So basically, all employers have to have workers' compensation benefit coverage, and it's usually done through an insured program or a self-insured program. Julie, what does the FMLA cover in the work injury setting?
So the FMLA is the statute that is intended to allow employees with a serious health condition time off to take care of themselves or other family members. Most work comp injuries are going to qualify as a serious health condition. A serious health condition is one generally that means that they are unable to perform the functions of their job. But if just because it's a serious health condition under the FMLA does not necessarily mean that it is a disability under the Americans with Disabilities Act. The FMLA requires up to 12 weeks of unpaid leave. It can also be intermittent, which, as many HR directors can tell you, can be a real pain. Intermittent leave is difficult to administer. FMLA also requires a continuation of medical benefits, and FMLA time cannot be counted under no-fault attendance policies. The FMLA statute calls for no interference with the workers' rights under the FMLA and no retaliation, which means you can't interfere with their rights and you also cannot retaliate against them for exercising those rights.
Julie, can FMLA run concurrently with workers' compensation disability?
Yes, it can, but certain things have to be done in order for that to happen.
And what's required?
So you need to make sure that the employee is notified in the handbook that the FMLA is going to be running concurrently with the workers' compensation. You need to have a policy in your handbook that tells employees beforehand that that's the way that it's going to happen. You also need to, at the time of the injury or at the time that the leave is going to, the need for leave is, comes up, you need to provide a designation notice under the FMLA.
Okay, would you introduce for us the Americans with Disabilities Act?
Sure. So the ADA provides protection for disabled individuals. It requires that employers who are covered by the Act provide reasonable accommodations, and it prohibits discrimination and retaliation. And as I said, the definition of disability is different than the definition of a serious medical condition, so you need to look at both the ADA and the FMLA separately.
Workers' compensation disability does not equal ADA disability. What's required in workers' compensation is an injury that prevents the employee from performing their regular duties. If they cannot perform their regular duties, it's going to be either full or partial disability. So this is really a wage loss standard. If you have a wage impairment because of your injury, that's a disability under the Workers' Compensation Act. Now, I understand that's not necessarily so under the ADA.
Correct. Under the ADA, you're going to need to see whether the person has an actual perceived physical or mental impairment. Whether it doesn't matter whether it's work-related or not.
So you don't even need an injury under the ADA?
Correct. It could be for a medical condition.
Or the perception of a medical condition?
Yes. Regarded as, which means that the person doesn't even have to have a disability, but the claim would be that their employer regarded them as disabled. Also a perceived disability or a history of a disability.
And the disability under ADA or the impairment need not be work-related?
Correct. Correct. You can break your leg skiing, and that could be a disability.
And you need not even have a wage loss to have an impairment under the ADA?
That is also correct.
So the triggers for the ADA to be invoked are very different than those for the Workers' Compensation Act. In running through that scenario, you can see that the ADA disability is a much broader concept than a workers' compensation disability, covering various things not work-related, not wage loss. However, most workers' compensation lost time injuries, I would think, would be covered by the ADA because you have a serious impairment of a major life activity, working, and to me, you have to at least do the analysis of whether ADA applies when you have a serious lost time workers' comp injury.
Yeah, that's correct. And the real area where it's going to come up is having to do with reasonable accommodations and in particular with needed time off from work. Because if they're on workers' compensation, generally speaking, they're not working, right, Steve?
That's correct.
So if they're not working, then they're not going to be needing a typical reasonable accommodation, such as a different keyboard or maybe a different type of a chair or something like that. But where this does come up, just to give you a little bit of an overview of what's required under the ADA for a reasonable accommodation. An employer must make a reasonable accommodation to a qualified individual with disability unless that accommodation is going to cause an undue hardship or a direct threat. So basically, what you do is you look at what are the essential functions of the job. Can the person do the essential functions of the job with or without an accommodation? If they need an accommodation to do the essential functions and that accommodation is reasonable, then it must be offered by the employer. This may require you to restructure a job, reallocate or reassign marginal job functions, modify a work schedule, or those sort of things. Give them give them different work equipment, that sort of thing. It is not required that you change the essential functions of the job. Now, up here on the slide, it says that reassign marginal job functions, not essential functions. Also, when it comes to determining whether there is an undue hardship or a direct threat, those limitations are very limited under the law. So if you are going to use those, or you're thinking about using those in denying a request for accommodation, you are strongly encouraged to seek counsel and seek some advice on that, because they can be very limiting. Where this usually comes up in the workers' compensation standpoint is having to do with unpaid leave. And unpaid leave, whether somebody needs to be provided with additional unpaid leave as part of a reasonable accommodation.
Great.
So
can we just try to flesh out an example for the audience of a essential function or a non-essential function? I'm thinking of a situation where perhaps you have a truck driver who's injured shoulder or arm, and can no longer drive the truck. Does the employer have to provide him another job under the ADA?
No, they don't. So if he cannot perform the essential functions of the job, then he is not protected under the ADA. He is not a qualified person with a disability. If he can, maybe he can drive, but he can't drive for the usual amount of time, right? Maybe he can only drive 8 hours, not 10 hours a day. Then that may be an accommodation that you might have to provide for him, because he can still do the essential functions, driving.
What if his job involved driving and washing the truck once a month, and he could no longer wash the truck for some odd reason? Would that be considered a marginal function that could be reassigned to others versus the essential function of his job, which is driving? That seems to be the core function.
That's a really good example of a marginal function, actually. I think that would be considered a marginal function. So what you want to look at is what's the nature of the job? You know, this is where employers want to make sure that they have written job descriptions, and that their job descriptions provide all of the essential functions. It's something that employers should be reviewing their job descriptions at least yearly to make sure that they're up to date and accurate, because that's what a doctor is going to look at in deciding whether to certify something for FMLA, or whether to provide, when providing information as to what sort of accommodation might be required.
What is the process of sorting out what potential accommodations can be made to an individual who's seeking to return?
So that is, under the ADA, that's the interactive process. Employers are required to go through the interactive process. If you do not engage in the interactive process, it could lead to liability. What this is that it's basically a discussion back and forth. It may not actually be an in-person discussion. It may be through documents or letters. But both the employer and the employee need to participate in the discussion in good faith. In this discussion, the employers are able to obtain relevant information to determine the feasibility of the reasonable accommodation, of providing a reasonable accommodation for the person. They are able to find out what sort of information, what sort of accommodation the person needs, whether it's reasonable to provide that, what sort of hardship is involved, whether there may be a different type of accommodation that may be possible that would reach the same result. And it's a discussion back and forth.
What may happen to an employer who refuses to engage in that process upon request of the employee?
Litigation. And that, it is directly required under the ADA. And, we see a fair number of claims brought by plaintiffs for failure to engage in the interactive process. So what about transition or light duty?
Well, you've given us ADA requirements where you have to determine essential functions. The ADA apparently does not require creation of new jobs, but it does require reassigning of existing jobs that would fit within the accommodations required. Now, in workers' compensation, light duty jobs are an essential tool that employers utilize to manage their workers' compensation claims. We see it done all the time. You have actual cottage industries of vocational rehabilitation firms that have grown up around trying to accommodate partial disability, get people work outside, or get people modified jobs within the existing employer. Now, what does the ADA say about that? Light duty for injured workers can be created. So this is light duty for workers' comp claimants, can be created. However, an employer cannot reserve existing light duty jobs or on-the-job injuries. So you cannot, in your existing workforce, just say we are not allowing anybody else to apply or utilize these light duty jobs, only injured workers. That's apparently prohibited.
That's right. That is prohibited because remember, the ADA has to do with any type of injury or any type of illness. So under the ADA, they don't want you setting aside light duty positions that may be somebody who is sick but not a work injury, and taking those jobs away from them in order to give them to work.
Sounds like you can't treat one set of workers differently than another set of workers in that setting.
Absolutely, that's exactly right.
But the ADA does allow the employer to create a light duty program for injured workers.
Yes.
Just not reserve existing jobs.
Right, you can't set it aside.
Okay.
And exclude workers that have other disabilities that are not work related from participating in those programs.
All right, what about the employer that says, I don't want the employee back unless they're 100%?
So this is a problem. I mean, like we said, the ADA is protecting people who have some sort of injury or some sort of illness. What it is basically saying at its core is that you cannot require employees to be 100% healthy. And so by the same token, under the ADA, you cannot require employees to be 100% healed. It's the same idea. You need to look at the job functions and say, can they do those essential job functions with or without a reasonable accommodation? If they can, then you have to let them come back and you have to make the accommodation.
Is this a refusal to engage in the interactive process? If an employer takes the position, they must be 100% or they can't work?
Yes, definitely. Okay. Definitely.
So that's going to trigger a problem with the ADA.
Yes.
I can see a lot of reasons for employers to not only engage in the interactive process, but to have a good light duty program to control their exposure under the Workers' Compensation Act. An employer under the Workers' Compensation Act does not have a duty to provide light duty, right?
Right.
They do under the ADA, depending upon the circumstances and if the employee qualifies for ADA protection. But there's nothing in the Workers' Compensation Act that says you have to have light duty.
Well, yeah, and you can think of it this way. If you are offering a light duty position for workers' compensation participants, then you're basically saying that they can do, the major functions of their job, the essential functions of their job with those accommodations. You're basically identifying what accommodations would be considered reasonable. So under the ADA, if you have a light duty position, so if you've gone through that, you've created a position that basically has accommodations, but you don't offer it to somebody who's, like I said, had a severely broken leg from skiing as opposed to something that happened at work, then you're going to run into trouble.
Okay. What if an employee declines light duty?
So they can decline light duty, from an employment law standpoint. If they want to, you can't force them to go back to light duty. So this is assuming, first of all, that our employee who is on workers' compensation, that you have run it concurrent with the FMLA.
By meeting the requirements with the prior notice, the handbooks.
And the certification process at the beginning of the injury.
You're not going to be able to utilize the concurrent FMLA.
Right, which means they still have their 12 weeks in a bank somewhere.
Okay.
12 weeks of unpaid leave in a bank somewhere that they can use in the future. So most employers do run it concurrently. So assuming that you have met all of those tests, and so you have an employee who is on workers' compensation, but also at the same time is on FMLA. Now, from a FMLA standpoint, let's say that employee does not want to come back to work. Can you fire them? The answer is no, because they're still protected by the FMLA. They can decline the light duty work and just stay on unpaid FMLA.
So FMLA protects their job. They can decline an offer to come back to work, but I can see a problem under the workers' compensation statute if they do so. They might lose their benefits. But again, the FMLA protects a different interest.
Yes.
Protects their job, protects them if they want to spend their time doing something else, but it does not prevent workers' compensation benefits from being changed in light of that decision.
That's right. That's right. So they still have the protections of the FMLA, which is your job protection benefits, and they have that up for the 12 weeks that they are out. The first 12 weeks that they are out.
What happens at the end of that time when they've run their FMLA?
This is by far the most common question that we get when it comes to the intersection between workers' compensation and FMLA. And that is, what do you do with the employee who is who's been out on a work injury, and they've been out for more than their 12 weeks? So they have exhausted all of their FMLA time. They have also exhausted, let's assume they've also exhausted all of their other paid leave times. So they don't have any more vacation time, they don't have any more sick, they don't have any more PTO. Can you fire them? Can you stop paying their benefits? And the answer is no, not initially. What you need to do is, because you've looked at the workers' compensation, you've looked at the FMLA, but you also need to look at the third part that was in our little diagram at the beginning here, the ADA and the PHRA. The EEOC has said that additional leave can be considered a reasonable accommodation. So if you have somebody who's been out of leave for, let's say, 12 weeks, and they come back, they're not quite ready to come back to work, but they're going to be able to come back to work in two more weeks. They need two more weeks. Then the question is, the FMLA doesn't require you to provide them with the additional 2 weeks. Does the ADA? And the answer is yes, it could. That could be a reasonable accommodation under the ADA.
And just from the comp perspective, because FMLA runs, does not affect the workers' comp entitlement. That continues independent and will be judged by the test under the comp statute. Right.
Now, one of the other things, we mentioned this before, one of the other things that's protected by the FMLA are benefits. So while you are, during the time of your leave, during those 12 weeks, your employer must provide the same benefits that they provided during your employment. This is your insurance, your health insurance. Now, most employers get a contribution. I mean, most employers don't pay all of their employees' health benefits. I'm sure they'd like to, but they're pretty expensive these days. So the FMLA, this section of the FMLA that's on here, 825-201F, or 210F, excuse me, requires that employees make arrangements to pay their portion of the health plan while they are on FMLA. And if they don't, then there are provisions whereby you can, stop those benefits. But again, that's something that I would talk to an attorney about before you do, because remember, the FMLA has not only retaliation provisions, but interference provisions, and which means that unlike a lot of the other civil rights type statutes, discrimination and retaliation type statutes, there is that additional cause of action where if an employer is found to basically interfere with an employee's ability to use FMLA, they could also be found to be liable for violation of the FMLA.
Can you think of an example of that?
Yes. So those kind of examples, they come from different types of things. One is not providing the right notices. One is your supervisor who says something not so wise. No, you don't really want to request FMLA, do you? Let's see if we can do something else. I mean, you always have those kind of factual scenarios come up in the case law where somebody says something not so wise, and it's the idea that the employer takes action against the employee to make them not want to use their FMLA leave. which is, their right under the statute. Let's see, what do we got next here?
That brings us to best practices. Now, I'll summarize what I think I've gleaned from all this. Advise and communicate. You have to advise the employees of certain rights in order to trigger the ability to use certain provisions under these acts. I'm most familiar with the work, and without doing those proper postings and having the employees sign the right paperwork at the right time, you cannot utilize that. Now, I imagine from what I've heard today, there's similar provisions for the FMLA to run concurrently with workers' comp. If it's not published in the handbook and prior notice given, you're going to lose as an employer, lose the benefit of having the FMLA run concurrently. Now,
yes.
What other provisions are there, Julie, that we should be aware of as far as advise and communicate?
So as far as, focusing just for a second on the handbook, things that you want to make sure is that, like you said, that it has that provision that that the two types of leave run concurrent, that workers' comp runs concurrent. Also, if you want them to have to use their paid leave as part of their FMLA time, that needs to be in the handbook as well. You also want to make sure that your handbook the FMLA policy in your handbook isn't more generous, accidentally, more generous than the FMLA itself. There is a case in the Third Circuit here where the employer gave in their handbook, mistakenly, it gave more employees entitlement to FMLA than the statute requires. The statute requires that you work for a certain number of hours, that you work for at least 12 months, and it also requires that there are a certain number of employees within a geographic area in order for the FMLA to come into play at all. That handbook did not include that third provision. And so, after the case went to litigation, the employer tried to say, well, no, they aren't protected by the FMLA. And of course, they lost that because their policy wasn't right. So you want to make sure that your policy accurately reflects what it is what the benefit is that you're providing. And unless you want it to be more generous than what's federally required, that it's not. You also have your general postings that are required for the ADA as well.
Now, communication is an important aspect of best practices as well. I understand communications are frequent with employees on leave. HR managers have a lot of correspondence back and forth, collecting medical certifications, advising leave requirements, and getting the paperwork back in time. I see this in even my workers' comp cases a lot. Employers are constantly asking for documentation.
Right, especially at the beginning of the process, right after the leave has been requested. You need to get certain doctor's notes and certifications, and there are strict time frames under the statute under which you have to do that.
In many of the cases where there's an open workers' compensation claim, there will be counsel. What can an employer do to communicate directly with the employee if there's, say, comp counsel?
So usually that is handled at the HR level. I will say also another thing to keep in mind with FMLA issues, and just anything having to do with an employee's health from an employment law standpoint, I understand this is maybe different from a workers' comp standpoint, is to be cognizant of confidentiality. Like, for example, FMLA communication should not be between a supervisor and an employee. They should be with HR. Because the supervisor should not know the medical information that relates to the leave. Now, I understand that may be different when you have the workers' comp also in the mix, but from a strict FMLA standpoint, that could be considered another type of interference claim, is not protecting the confidentiality of the information. So you do need to be careful about that as well.
And correct me if I'm wrong, but that interactive process under the ADA to find out if there's an appropriate accommodation, wouldn't a supervisor normally be involved in that process because he knows the job, he knows what can and can't be done with the job?
Yeah, and so it's a real delicate line to kind of for employers to navigate as far as medical information is concerned. But like as far as the ADA is concerned, first of all, if they are working, then they're not on leave. If you're going, the only FMLA, the only way that the ADA is going to flow in with the FMLA is if they need more leave. If they need more leave or they need some sort of intermittent leave. If you are having a discussion as to what sort of equipment an employee might need, maybe, to do their work, or those sort of accommodations, that's going to be different. That's not an FMLA issue. That's an ADA issue. But at the same time, a supervisor does not need to know why the person, what medical condition requires a person to need the accommodation. They only need to know what the accommodation is.
Or the capabilities of the employee.
Yes.
I can imagine scenarios where the supervisor is told there's a lifting restriction. Can he do the job with this lifting restriction? But he need not know what's causing the lifting restriction.
That's exactly right.
Okay, so is there more best practices? Communications between risk management and human resources. Tell us what's required under the ADA, FMLA for that.
So this is really going to come up with the FMLA, and this is going to come up with those certifications that I was talking about, right? If you have I'm imagining that employee injuries are usually handled by risk management. Is that right?
Yes,
yeah.
And often outside adjusters.
Right, and so at the time that an injury occurs, the first call may not be to human resources, right? They would be to the different department. They would be to risk management. But if you want to use the FMLA leave concurrent, you need to bring HR into the mix. You need to bring them in so that they can start the process. They can get those certifications within the time frame set forth in the statute.
And the confidentiality and safekeeping of files, that's very different under workers' comp than it is under the ADA.
Yes.
You've already told us about keeping the exact condition out of the mix.
Right, but you also need to keep your, HR professionals know this, that you need to have your medical documents, anything having anything to do with medical, in a separate folder than your personnel files. You need to keep those files under lock and key. There are different, provisions. And if you don't do that, if you have those documents intermixed, then it can be a violation.
So there can be trouble for not keeping track of the records or keeping them in the right place.
Correct.
But in workers' comp, we see records flying around because they're kind of part and parcel of what we do on a daily basis. It's a different treatment of the same issue, but you can see there's a potential minefield here if you do it wrong.
Yeah, and that's what makes all of this so dangerous, is that it's not enough to look at something as just a work comp issue. Other things come into play as well. If you have medical information, it can't be in the personnel file, even if there isn't a discussion going on about accommodation, or even if there isn't a discussion going on about FMLA leave. Your FMLA paperwork, if you do want to run it concurrent and you do have those certification stuff, all of those papers cannot be in the personnel file. They need to be in a separate file.
So why don't we run through some hypotheticals here to kind of put some flesh on these concepts for our clients. Let's pretend. Here's a hypothetical. Joe Carpenter calls out of work for 3 days, and on the third day he mentions he hurt his shoulder on the job. Now what?
What do we do with this one?
I'll start with workers' comp. This is the easy one. It's that notice that his problem is work-related that triggers a workers' comp investigation. Medical information will be gathered. There may be a medical exam somewhere down the road, but basically you'll be looking at the medical records to see if it's a work-related problem, and if he or she can't work, in this case Joe, then disability may be triggered. If he meets the waiting periods, and medical benefits will be provided. So this is an easy one for workers' comp. It's standard claim investigation. What happens in this scenario with FMLA?
So what you need to do is it focuses on whether Joe is going to need time away from work. If he's going to need time away from work, then you may need to trigger the FMLA process, get the paperwork together, get his certifications to him, get the designation notice, and start gathering the information from his doctor.
Is there a minimum period that triggers the FMLA?
So it's a case by case basis, really, is what it is. So, but if you want to keep in mind that what looks like it could be a fairly small injury right now, maybe it's only a couple of days right now, but then it may be more, and then it's a couple more, and then it's a couple more. If you don't start that FMLA process, you don't start the FMLA clock running.
So this process can be started two ways. One, the employee could say I want FMLA, or the employer could say, we want you to have FMLA to run concurrently with your workers' comp.
Yes, you can provide the employee with the paperwork. I mean, they still have to get the certifications from their doctor, but you should, if you know that somebody is missing time from work and it may be because of a medical condition, it is wise for employers to start that discussion.
Does the ADA come into play in this scenario?
If Joe is still working, he's still in the workplace, and you may need to decide what his restrictions are. Does he have lifting restrictions?
What if I'm sorry, go ahead.
Well, I was just going to say, can he still do the job? Can he still do the essential functions of the job? Because remember, if he can't do the essential functions of the job with or without an accommodation, then he may not be protected under the ADA.
What if he's out of work but wants to come back? And he says, I have a lifting restriction, but I'd like to work. Can you accommodate me?
Then that's when you have to go through that interactive process, and you have to keep in mind you can't have a 100% healed policy.
Wouldn't this be nice for a lot of our workers' comp administrators to hear the employee wants to come back and would you please accommodate me? We often have a different approach to this. It seems these two acts were designed from different philosophical bases. With the ADA, you're expecting employees are dying to get back to work. They just need a little help.
That's right.
In the workers' compensation setting, we frankly run into a lot of reluctant employees. Then the employers are trying everything possible to get them back. So different philosophical foundations, but same problem.
Yep.
Do we have time for one more hypo?
Yeah, I think so. Okay,
right.
So this is, we sort of touched on this a little bit, but okay, so we have Bob here. Bob suffers a work-related injury. He's exhausted all of his FMLA, all of his other paid leave, and he's still out of work. His doctor says that he's continuing treatment but cannot return to full duty. What do you do now?
Well, in workers' compensation, his disability continues. What the employer should be doing is examining his capacities now to see if there's a residual earning capacity of one sort or another, and examining whether that original employer can provide work within that capacity. That's basically the way it would be treated under workers' comp. Otherwise, the benefits in a wage loss jurisdiction like Pennsylvania would just continue indefinitely.
Right. Okay, so from a FMLA standpoint, we don't really have an issue because it says his leave is up. He's used all of his leave. From an ADA standpoint, you will remember that I said that even if an employee has used all their FMLA leave, additional unpaid leave could be considered a reasonable accommodation. Now, in this scenario here, the doctor says he's continuing treatment but cannot yet return to work. So you don't have information as to when he will be able to return to work. Indefinite leave is not a reasonable accommodation. The question is, when does leave become indefinite leave? Because I'm sure you've seen a lot of these notes, Steve, where the doctor says, not ready to come back to work now, I'll see him in a month. Mm-hmm. And then in a month, there's another note, not ready to come to work now, I'll see him in a month. So the question is, when does that become indefinite leave? There are provisions under the FMLA under the ADA, whereby the employer can get additional information as to, for example, hey, doctor, you said last month it was only going to take a month. Why were you wrong last month? What has changed? And those sort of things. And the key is to try and make the determination that what the person is really asking for is indefinite leave, which is not a reasonable accommodation. You do not have to keep jobs open for people from an employment law standpoint for forever. You're only required to make reasonable accommodations. Indefinite leave is not a reasonable accommodation. We have had lots of clients where we've walked them through this process of obtaining additional documentation from the doctor, and ultimately making that decision that no, what you're really asking for is indefinite leave. We're not required to do that under the law.
Okay, so you peel away the FMLA because time is run. You peel away ADA because indefinite leave is not required, you still have him on comp, and he could be there forever.
Yes,
Unfortunately, we have files where those employees are still out many years later.
Yes, but if he's no longer entitled to the FMLA leave and he's no longer covered, he's not requesting a reasonable accommodation under the ADA, you can terminate him and stop paying his insurance benefits, not his work comp benefits,
Right.
but his insurance benefits. So he would, so you don't have to keep his position open for him.
A ray of sunlight in an otherwise
Yes.
bleak situation. Well, I think our time is about up. Our sponsors are after us, so thank you very much for attending our webinar, Solving the ADA, FMLA, and Workers' Compensation Conundrum. Our next program will be on April 18th from our Mount Laurel office, entitled Navigating the Issues Brought On by Legalization of Medical and Recreational Marijuana. Our New Jersey attorneys will discuss how new legalization laws interact with existing federal employment laws, as well as various state workers' compensation laws and policies. You can learn more about this program and other Weber Gallagher events at www.wglaw.com/WG University. Thank you very much.
Thanks.